Welcome to this episode of Bringing the Law to Your Doorstep. In this particular session, we'll be discussing very interesting matters in the form of questions. We've received a plethora of questions surrounding the suspension and revocation of sponsor licenses, the enforcement actions that are taken by the Home Office, especially against employers that are unable to comply with their sponsorship duties in the UK. So this is going to be a question and answer series, but we are going to have it in a very conversational tone so that, it becomes more practical and relatable to our audience. So once again, I'm joined by my lovely brother, Kujuchu Esibuafo, and we hope to do justice to your questions in this edition. So welcome, Kuju, to this edition of Bringing the Law to Your Doorstep.
Thank you very much, Mamo. I'm very fortunate to be here and eager to speak to our people who have been following us time and time again. Today, I don't know if you've mentioned this, but there's been a wind of revocations going on. And I believe that if you are an employer and if you are a migrant worker in the UK, then this video is for you, so you can't miss it out. You have to stay glued to your seat and see what's unfolds today. So, Emmanuel, over to you.
Okay. All right. Thank you. So, Kodo, we are just going to discuss the questions briefly. We're going to have it in a question and answer format. So,
exactly.
So briefly, I'll start with the questions, but we'll join in wireless actually. Okay. So, what at all is the suspension of sponsor license? I just want you to give a brief overview so that our audience can understand the revocation, suspension of sponsor licenses.
Mano, thank you very much for answering about revocation and suspension. I'm sure most of our viewers would want to know what that entails. Suspension basically means that Home Office believes that there might be an element of a breach, and often at times the breach has to be very serious. Home Office has compliance officers that are monitoring every employer that has a license, and so when they believe that their intel is legitimate, they would write to you, the employer. Often at times, the authorized officer will be the one to receive this is via their email, and they receive a notice that the license has been suspended. So the moment they know, they send that notice. And so you would have 20 days to respond to it. So this is temporal because, again, they're running into investigations, and the employer has 20 days to look through the alleged breaches and then respond to them. After they send the response, Home Office has 20 days to deliberate with other relevant stakeholders and then make the decision. Often at times, the suspension, like I said, is temporal. So it's in lieu of revocation, potential revocation, which is permanent. And so that means that you lose your license entirely. And unfortunately, it's quite problematic for many people facing these challenges.
So we'll now proceed to talk about the grounds for the revocation of a sponsor license, the suspension, the downgrading of a sponsor license. So the enforcement actions can be suspension, revocation, downgrading of a sponsor license, relegating your COS allocation to 0, and even reporting you to the police. It's clear in the sponsor guidance, specifically for employers, that the sponsor license grant, or if you like sponsorship, is not a right. Okay, it's not an entitlement, but it's a privilege.
Exactly.
Yeah, it's a privilege. And if it's a privilege, then you should understand that as an employer, there are incidental responsibilities and obligations under the sponsor guidance you are supposed to comply with. And if you fail on any of these responsibilities, then there are implications and consequences for that. So the consequences are the enforcement actions I've already highlighted, and these are undertaken by the UK Home Office. Now, what are the duties and obligations of an employer under the sponsor guidance? The law makes it clear that there are record-keeping duties, there are monitoring duties, there are reporting duties, there is compliance with what the law refers to as the wider UK law, and there is a demonstration of a conduct, which is conducive to public good. Now, someone might ask, or an employer might ask that, as an employer, if I have a sponsor license, what are some of my reporting duties? What are some of the things I need to report? So if there is a change in the circumstance of an employee, if a worker changes location, if a worker, for instance, fails to report to work within 28 days after being issued with a certificate of sponsorship, if a worker, for instance, fails to attend work for 10 consecutive days continuously, then you must report this change to the Home Office through the sponsor management system.
Exactly.
If there is a change in the circumstance of the organization, if the organization opens a new branch, for instance, if there is a merger or anything of that sort, you are supposed to report this within 20 working days through the sponsor management system to the UK Home Office. So these are some of the reporting duties. But yes, aside the reporting duties, there are also record keeping duties that employers are obliged to take note of. Now, someone might ask, what are some of the record keeping duties? So I would allow Kojo to weigh in on this one to tell us what records an employer in the UK is supposed to keep as part of the employee database in their organization.
Right. So first and foremost, there are two ways of going about it. Is your focus on your employers. There are two types of employees. The ones that are already satisfying the UK labor test, the residential labor test. So if you're a citizen, you're pre-settled or you're settled, you've obtained indefinite to remain, then as an employer, all you need is their passport. So a copy of their bio page, and of course running DBS check for any criminal records. But if you're hiring migrant workers and you're obviously overseas, then as part of the onboarding, the recruitment process, you need to have a copy of their health results to the TB test. You need to make sure that you have a copy of their passport as well. And their right to work checks are all very, 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 very important. And it must be stored properly. Yeah. And so they can't overstate the importance of having an adequate, secured HR system. There are many HR systems that exist out there. There's Bright HR, there's Atlas. Mano, can you throw a few of them in there?
Yeah. The HR systems, quite fortunately, King's Court Law has partnered with our sister company Compliance 360 to come up with an HR system called B360. So B360 helps you as an employer to do things like payroll, to communicate. It's a platform, a digital platform for communicating with the employees, storing all their database. It basically automates the system for you. So things that you would have otherwise manually done, which would have been very difficult. For instance, if you were to monitor the expiry date of your employees and you were to do that manually, we all know how demanding that could be. But B360, amongst many other good software platforms, would help you to automate these things so that you have a system software in place to monitor and to properly keep some of these systems for you. So we usually advise our clients to go in for system softwares to properly keep employee information.
It makes your life easier.
And to make it very
because some of us can come in and do unannounced visits, interviews. Some of them can be in person, so they can check your records. You have to allow them to do so. Or it can be done virtually via Zoom.
Yeah.
And so when it's done via Zoom, there'll be screen shares and we're done in a couple of times for a lot of people. Yeah. And that's why it's very good because most people might have Excel spreadsheets and all that. But I believe it's quite draconian. It's quite, old fashioned. And it makes it very difficult when it comes to right to work checks. Now you have to open folders and whatnot. But with the B360 hub, right? The B360 is so unique that it has it has compliance in mind as far as migrant workers are concerned. And so when it comes to right to work checks, there are folders that are labeled and you are able to even note down the expiration dates of all your migrant workers. And so when it comes, and basically that falls under your reporting duties. And so 3 to 6 months before their right to work expires, you are getting notifications. And it's so unique. It makes it very easy, because when it comes to your rotas, when it comes to your holidays, annual leaves, everything is centralized and everything is properly done. And you can easily communicate with your workers and stuff.
Like my colleague Kojo said, the sponsor guidance is more or less the Bible, I always say.
Yes.
For employers to be able to gain mastery over their obligations and their responsibilities under the sponsor license system. So yeah, record keeping duties, reporting duties, compliance with the wider UK law, normal employment law, and basically making sure that you are doing the proper and the correct checks as an employer to ensure that you don't breach any of these duties. Now, what is the downgrading of a sponsor license? I just want to make a comment on the enforcement actions taken by the Home Office. What does it mean if your sponsor license is downgraded? If your sponsor license is downgraded, the sponsor guidance makes it clear that it simply means that your sponsor license has been more or less reduced from an A rating to a B rating. And when that happens, the impact on the employees is that no fresh employee would be able to work for your organization because you cannot issue new certificates of sponsorship. But for the old employees you're already sponsoring, the current ones, of course, they will not be impacted. They can still continue working for you. And if you have any old COS, you can extend their leave with the old certificates of sponsorship that you have, but you won't be able to issue any new ones under the sponsor management system. Now, anytime your sponsor license is downgraded, what the Home Office usually does.
I just want to quickly throw in so I don't lose my train of thought. Just another valid point for us is continuing. If you're also during the period where the sponsor license has been downgraded, if you are a migrant worker in your country, home country, and you are about to travel, you'll still be permitted to travel because you fall under that category of people that are under current workers. I mean, you're not a current worker, but you are still allowed to come into the country legally. It's only when the license has been revoked that obviously if you have a COS and I mean, you are now coming, you will not be able to give in entry clearance. So I just want to briefly clear that for those that are watching. And so they know.
So the meantime, your sponsor license is downgraded. The Home Office comes up with what is called an action plan. So the action plan is a cluster of practical steps you are supposed to take as an employer to restore your sponsor license back to an A rating. If you fail to comply with these action plans within 3 months, it leads to automatic revocation. So you move straight from having your sponsor license downgraded to having it revoked. You don't go through the process of suspension. And for the downgrading of a sponsor license and the suspension of a sponsor license, these are temporary enforcement actions taken by the Home Office. So anytime that is done, the law expects the Home Office to give you the opportunity to respond, what lawyers will refer to as odi or transparent. So you are given the opportunity to make representations against the downgrading of the sponsor license and the suspension of the sponsor license within 20 working days. But if your sponsor license is revoked, you don't have the option of an appeal. All we do, especially as legal aspect, is to do what is called a judicial review to challenge the revocation of the sponsor licenses. So yes, if your sponsor license is downgraded, is suspended, is revoked, you don't have to throw in the towel as an employer. There are practical steps that you can take to restore your sponsor license back to an A rating in the case of it being downgraded, or to get back your sponsor license in case it is suspended or it is revoked. And you should also know that if the sponsor license is suspended, your name is extricated from the list, from the public list of registered sponsors. Okay, and this has potential implications on the reputation of your organization. Because, for instance, if you are working in a regulated industry, if you are a care company, or if you are a food operating business, if you're a care company, the CQC, if yes, you are registered with the CQC, they will be notified of this particular suspension of the sponsor license. If you are registered with a local authority or any specialized body, they would also receive a notification to this effect. So that affects, exactly. So that affects the reputation of your organization. And in the case of revocation, it is actually worse. Now, when we through the sponsor guidance, specifically Annex C1, C2, C3, the law makes it clear that there are circumstances where the Home Office emphasis on will revoke your sponsor license. There are circumstances where they will normally revoke your sponsor license, and there are circumstances where the Home Office may revoke your sponsor license. So there are mandatory grounds for revocation, and there are discretionary grounds for revocation.
Yeah.
Now, what are those mandatory grounds? I mean, the list is a lot. We cannot exhaust all here.
It's exhaustive. So
yes.
So should I pick a few of them?
A few of them I would like to throw light on is, if you are making a sponsor license application as an employer, for instance, you should make sure you don't use falsified information.
Exactly.
Because once that is discovered, it is automatic revocation of your sponsor license. You cannot do that. You should also ensure that the price or the amount of money, if you like, the salary, yes, indicated on the certificate of sponsorship, the COS, is the correct amount paid to the employees in practice of your sponsorship duties. So you cannot tell the Home Office that, hey, I'm paying my employees £20 an hour, whilst in practical terms, you'll be paying them less than that amount per hour.
Genuineness is key.
Genuineness is key. So that would occasion a mandatory ground for revocation. There are a cluster of others. If you cease to have a trading presence, if there are unspent criminal convictions, there are a whole list of circumstances that would cause the Home Office to revoke your license without even, without blinking an eye.
Section 15 of the Immigration and Asylum and Nationality Act of 2006 also touches on illegal workers, employing illegal workers.
Yes.
It's important to make sure that every worker you're hiring, that they have right to work in the UK. And so if you're hiring workers, you have to do the right to work checks. And that's why it's very, very important. That's why they don't overlook it. And so it's not enough to say that you didn't know. If you are found, and if you're watching right now, you have an employer who doesn't have the books, who doesn't right to work, you can either be penalized. There are fines that you can pay, that you may like to pay. And I think it's £60,000 per worker. That's a lot of money against you having to face reputational damage as well. Then aside that as well, you may face prison time. So these are serious issues. So it's really, really important you're mindful of some of these things. And Home Office always has reasonable grounds to take action against you. So please, if you're not certain, you can always reach out to us. So, Emmanuel, something you're talking about, I think, bringing back to a case that we're dealing with recently, I think you're very passionate about it.
Yeah.
And it was about a lady.
Yeah.
Does it bring anything to remember?
Yeah, that's. There was a particular case we dealt with, and about a lady who was one of our clients who was working and an employer for them in England. And she relocated to Scotland because her employer had their license revoked by the Home Office. So she relocated to Scotland because you know that when the sponsor license is revoked, even prior to the 60-day grace period, the Home Office usually gives to affected employees, sponsored workers in there. They give them the opportunity to also seek being sponsored by other employers. So this young client of ours, very lively.
So just briefly, as he's talking about it, for the purpose of those who are following, I think this part is really, really crucial.
Yeah.
So she was already working for the employers.
Yeah.
And if you are a care worker on the care route, you are able to work 20 hours elsewhere.
Yeah.
She was currently doing so because unfortunately when she was working, there wasn't enough hours. And that's another issue altogether.
Yeah.
So while she was working elsewhere,
yeah,
the current employer's license was revoked.
Yeah.
This is very key to the story. But please continue.
So she relocated to Scotland and was working for another employer. And this lady, in the middle of her work, receives a letter from her employers in Scotland that she has been dismissed. And the reason why she has been dismissed is because she has breached her visa conditions and stopped working for her old sponsor. And that, as a result of that, she's been dismissed for some other substantial reasons.
Ridiculous.
And this was actually a blow in my face because during the consultation, this client was in tears, very emotional.
Julian.
Yeah, very emotional, going through a lot. To have been able to even relocate from England to Scotland, I mean, that was quite A very
financially
bold
draining,
decision. Yeah, very bold decision to take. What I need employers to understand is that if a sponsor license of an organization is revoked and an employee, an affected sponsored worker, comes to you, for instance, and is seeking employment, the revocation is no fault of that sponsored employee. The revocation has to do with the employer. So the employee cannot be held responsible for the revocation of the license of an employer if they played no role in it. And you cannot say that you've dismissed an employee just because the license of their old sponsor was revoked. And because of that, they stopped working for their sponsor. No. Once there is revocation, every sponsored employee at that particular time is entitled to stop working for the employer and to seek solace elsewhere. When I say solace, they can seek sponsorship from a new employer. So dismissing that particular employee was totally wrong. It was totally in breach of the laws. And what actually got on my nerves was that the employer said that the dismissal was because of some other substantial reason. And when you go through the Employment Rights Act, Section 98, and if you read through, even in Section 94, the laws are clear that even if you are dismissing for some other substantial reason, that particular ground for dismissal should be reasonable. It should be rational. It should be in tandem with the laws. It should be legitimate. It should be procedurally fair. The ground for dismissal should be clearly stated, and the grounds are in there in the Employment Rights Act. So if the employee doesn't fall foul of any of those listed circumstances in the Employment Rights Act, you cannot dismiss them. And that was the unfortunate situation of this particular client I'm talking about. So yeah, I want employers to know that if an employee comes to you, as long as they are within their 60-day grace period, and if they have situations where the sponsor license of their employees, their old employers, have been revoked, it is still legal to sponsor them to work for you. Okay, they can still work for you, gain the experience, and later on, you can decide to sponsor them.
And this is why it's always important for employers to understand what compliance is all about.
Yeah.
With our firm, you realize that it's not just immigration. There's a thin line between immigration and employment law.
Yeah.
Because it's intertwined. It's almost inextricable.
Yeah.
And so it's not just on the part of the migrant workers to know. There are many employees that don't know.
Yeah.
I had a colleague of mine, who, it's not even a colleague, it's a client.
Yeah.
But I know quite well. He was a colleague and then became a client. And he was in Scotland. Now he's in Australia living a good life.
Yeah.
He dedicated his whole time after obtaining after switching from obtaining his master's to postgraduate work visa.
Yeah.
He got a job, working at Audi, and unfortunately, they let him go. Why? Because they said that he didn't have right to work, and that wasn't the case. Because at the time when they wanted to dismiss him, he had put in an application to switch, and they weren't even going to sponsor him regardless.
Yeah.
But as far as the law is concerned, the immigration rule section 3C,
Section 3C,
his right to work continues pending a decision on his application. But most employers don't know some of these things, and it's important to make sure you have a legal representative or an immigration expert that you can consult with, so you can know some of these things. Because at times, there's that fear that you might be chastised, or you might be scrutinized, or there might be some form of sanctions being imposed on the employer. So at the risk of going through that, they would rather just take action and cut them off. But by doing so, we are still breaching the rules. So please, if you're a migrant and you're in the UK, it's important that at every stage, your first course of action, if there's any problem, any sort of problem, seek legal advice. So please do not turn a blind eye to abuse, to exploitation. Employers don't always know.
Yeah.
And if you're an employer watching this video, this is a call to action. You need to seek guidance, you need to seek support, and support is really available. You can seek our services or other competent lawyer or legal services.
Okay. So yeah, this is what we are dedicated to doing as Kings of Law. Like we always say, we bring the law to your doorstep. We want to strategically use the law to, inform and enlighten as many people as we can here in the UK.
Right.
Both employers, employees, even the Home Office. Because like my brother Kujo said, they don't always know what they are doing. And at times it's really difficult and disturbing when they come up with certain decisions which are not in tandem with the law. So yeah, we are hoping to have subsequent series where we'll discuss a lot of employment related issues, because we've been receiving a lot of queries, a lot of calls trying to address some of these issues. And yes, we're going to make a conscious effort to cover as many of these subjects as we can. So yeah, till we meet the next time, this is King's Con Law, and we bring the law to your doorstep.